question, I'm coming at from the other way that Mr. Sadow did. Did anybody from the district attorney's office or any witnesses in this case contact you about Ms. Merchant's motion from January the 8th of 2004 until today?
Did anyone contact me about her motion?
Yes, from the district attorney's office or any witnesses or anybody else involved with the case besides the defense?
Other than the call the only personal call that I had was with Gabe Banks. I never spoke to anyone else, and to my knowledge, he's not a part of this, so.
That's all I got, Judge.
Thank you, Mr. Stockton. Mr. Durham, if you're still with us.
No questions, Your Honor.
Thank you, sir. Mr. McDougal.
Good afternoon, Mr. Bradley. You have certain information about the relationship between Mr. Wade and Ms. Willis that is not privileged, correct?
Well, that was my determination, so I think he disagrees with it. So what we're going to say his opinion's a little irrelevant on that point.
Do you understand that the court has ruled that certain information that you have about the relationship between Ms. Willis and Mr. Wade is not privileged?
I have the court's ruling, as I understood it, and as my lawyers and I understood it, of the privilege not existing was based off of a conversation that was had in my office, in the back of my office, which was confidential, with Mr. Wade and I. That's what was asked of me on yesterday, and that's what the ruling, to my knowledge, unless I'm being corrected here now and saying that it's more, it was that particular piece that the judge said did not have privilege.
And have you testified already today to the sum total of your knowledge of the relationship that is outside the scope of the privilege according to the court's ruling?
Can you ask that again? I'm sorry, I didn't understand it.
Referring to what you understand to be the information that is not privileged, have you testified to the sum total of that information?
I think I have, yes. I think I've testified to that, yes.
All right, sir. That's my questions.
Thank you, Mr. McDougal. Mr. Rice.
Thank you. Mr. Bradley, at least as of February 15th, when you first testified, you said that you still considered yourself a friend with Mr. Wade, correct?
I think I said that, yes. I think I did, yes.
And you've been friends with Mr. Wade for over 10 years, correct?
That would have been fairly accurate, yes.
And you recall communicating with Ms. Merchant about this case and about Mr. Wade and Ms. Willis's relationship, correct?
An object is to asked and answered and cumulative by all three of the previous.
Sure. We don't have to lay that foundation. Why don't we combine it with the next question where you've got a new point to make?
Okay. Mr. Bradley, when you communicated with Ms. Merchant, did you tell her any lies about Mr. Wade and Ms. Willis's relationship?
Did I lie to Miss?
That's a simple question, Mr. Bradley. You're a lawyer. Did you lie to Ms. Merchant when you told her facts about Mr. Wade and Ms. Willis's relationship?
Not that I recall. I don't recall. I mentioned earlier that I speculated on some things. I've testified to what I did know, so I can't recall whether or not no.
Mr. Bradley, speculation is kind of a weaselly lawyer word. let's speak truth here.
I'm gonna
You're under
object
oath.
to argumentative at this point, Your Honor. It's not
All
asking relevant questions.
All
Mr.
right, let's find a
Bradley,
question, Mr. Rice.
Mr. Bradley, when you were communicating different details of the relationship between Miss Willis and Mr. Wade to Mrs. Merchant, did you lie to her about any of those details?
Objection asked and answered twice.
I don't think he's answered it yet.
I don't recall ever whether any of it was a lie or not
Well,
at this time. So
at the time you were communicating with Miss Merchant, you were still friends with Mr. Wade, correct?
yes,
And at the time you were communicating with Miss Merchant, you knew that she was talking to you in her role and capacity as an attorney in this case, correct?
correct.
And you knew that she was going to use that information to somehow benefit and file a motion, benefit her client,
I'm gonna
correct?
object to
I did not know that.
Okay,
So
see,
I did not. Well, I'm sorry.
so as an attorney yourself, you are testifying here under oath that you had no idea what Miss Merchant was going to do with all the details that you were giving her about Wade and Willis's relationship.
So at the time, no, I did not. I knew that Miss Merchant was gathering information. That is correct.
And did you lie to her when you told her that the relationship began
All right.
before
I
2020?
don't think we need to drill into specifics. He's covered it at a high level. I don't think we're going to get much out of this.
Mr. Bradley, isn't it true? The only thing that has really changed, well, you were speaking to Miss Merchant, whether by text or by telephone. You never said to her that I don't remember or that I'm speculating, correct?
I don't recall.
Well, you've looked through a whole lot of text messages. Do you remember ever seeing any communication from you that said, I don't remember?
Yeah, through the messages that I don't have all the messages in front of me, but no, I don't recall if I ever said I don't remember.
Do you recall seeing any text messages where you replied to her or gave her details where you said, I am speculating about this detail?
No, I never used the word speculating. No.
And the only thing that's changed between then and now is that phone call from Nathan Wade's friend, Grave Banks, correct?
No, well, Gabe was my friend, and I actually stated that the first day that I was here was that I've known Gabe for a few years, and that we were not were, but we are fraternity brothers, and so I never said that that anything changed behind Gabe Banks.
So you never told Miss Merchant that you were worried that they were threatening you?
Objection asked and answered when he was asked this on February 16th and today.
Mr. Rice, we've covered this.
And just to be clear, you didn't attend college with Mr. Banks, did you?
I did not attend college with Mr. Banks.
When you referred to him as your fraternity brother, y'all just both happened to have pledged the same fraternity, different colleges, different chapters.
Well, that's what we consider fraternity brothers, yes, sir.
And as a normal course of your relationships with your friends, do you pass on lies about your friends?
Have I passed on a lie about a friend? Is that what you're asking?
Is that something you normally do, Mr. Bradley? Do you tell lies about your friends?
Have I told lies about friends? I could have. I don't know.
Do you tell lies about your friends about a case of national importance?
Objection as to
All right, overruled.
I could have. I don't know.
Mr. Bradley, I notice you're not looking at me.
I'm looking at you on the screen only because I was accused of, and I did the same thing to Mr. Sadow when
All
he
right,
was on the
what's the next
screen.
question, Mr. Rice?
No further questions, Judge. I think it's clear.
Thank you, sir. Mr. Gillum.
Good afternoon, Mr. Bradley. A few questions. A lot of folks have taken up the questions that I wanted to ask, but I've got a few left here.
We'll see.
We'll see. You said Mr. Bradley, you said you didn't know what Ms. Merchant was going to be doing with the motion that she sent you. You remember that testimony a few minutes ago?
I think I said I didn't know that. I knew that she was gathering information. Yes.
Well, let's look at the title of the motion that she sent you. Do you
That-
remember
That was
reading?
sent on the 6th.
Excuse me, do you remember reading the defendant Michael Roman's motion to dismiss grand jury indictment as fatally defective and motion to disqualify the district attorney, her office, and the special prosecutor from further prosecuting this matter? Do you remember seeing that in the draft that you read and reviewed?
Yes.
So when you tell this court that you didn't know what she was up or what she was going to do, she kind of gave you a hint, didn't she, in the title of the motion that she sent for you to read? Didn't she? Yes or no?
I read the title of what the motion was.
And there wasn't anything in the title that threw you off. Pretty straightforward speaking title, isn't it?
Correct.
So you knew that what she wanted was information from you so that she could then file a motion to dismiss the grand jury indictment, to motion to disqualify the district attorney and her office and the special prosecutor from further prosecuting the matter, right?
I'm gonna object to speculation.
You knew that, didn't you?
Overruled.
Yes or no?
When she sent that motion, yes.
Okay. And you knew that the special prosecutor that to whom she was referring in that motion was Mr. Wade, correct? You knew that
Yes.
because you read the motion. You said you reviewed it, correct?
Yes.
And we're not going to go over all of the, number one, because we don't have time, and number two, the court wouldn't let me. But but there are a few things that I do want to ask you about in that response, in that aspect. Now, in that motion that you said you reviewed, on page 6 of that motion, well, on page 5, it starts off with, how do we know this? And there's a question mark.
All right.
Hearsay.
Yeah, Mr. Gillen, I can appreciate what you're doing. I think that's something you can do at argument. He said as a whole that he got the motion and he's had his responses to his opinion of how he handled it. I don't see that, again, this really being necessary to go through it line by line of what.
Well,
he reviewed.
a little indulgence, Your Honor. I'm not going to go, this isn't going to be a 40-minute death march through the motion. I would like to ask about a few bullet points that capture under this, and then I'll move on. But I would
Yeah.
ask the court's indulgence in that respect.
Again, I think we've covered it, and I think that you'll be able to argue that this was in that motion and that he had a chance to review it and he never objected to anything in there, or raised it. So
That's a problem, and always ending up last.
it very much is. The next time asked, I'll reshuffle the order.
Well, we did earlier with Mr.
Yeah.
Wade, and then
I hear you.
that was kind of,
I
and
hear
then
you.
the court said we had to go.
Y'all need to draw straws next
There
time.
we go. I'll go with that.
All right. Anything
Thank you, Your
else?
Honor. That's all I
Okay.
have.
Okay. We had Mr. Kucherov potentially still on Zoom.
Yes, Your Honor, and I have just a few questions.
All right. Could we add a spotlight to Mr. Kucherov? I'll let you know when we're able to proceed.
Judge, before he starts, can I take a 5-minute restroom? It's been
Absolutely.
2 hours.
Yeah, we've been going 2 hours. So let's come back at 4 o'clock. I'll also note for the record that we received notification from Mr. Cromwell on behalf of Ms. Latham, and he said he was waiting her presence. And I don't know if he later decided to join us by Zoom, but I don't think he was electing to log in. So after Mr. Kucherov, just in terms of timing, Mr. Abadi, do you have any expectation of how long your, if any, questioning would last?
I don't imagine my question would be very long.
Okay, well, let's get back in at 4 o'clock. Mr. Bradley, you can just step out of the jury room.
Straight up. Hey, Mike. Who wants to talk to you?
Fine or what? Lawyer. I want to say, Gilbert? Oh, yeah.
You look on him and he's like.
Good talking.
They make a style move.
I know. I love reading that.
I like the new haircut, man.
Thanks, man. I actually. Good.
Yeah, let me find somebody.
I'll get one for you.
Lunch, bro.
I'm trying to figure out what's nice. Yeah. Well, so what I'm doing. Yes. I'm going out.
Sure, Chuck.
Yeah.
Damn,
Damn, yeah. I'm just gonna admit all of them, but I'm trying to find the ones ahead so that you can, you know.
Representing?
Yeah.
David
yeah, add it
Schaefer.
back.
Thank
you. That was
was elected. That was at a steakhouse, but it was some 75 to 100 people there.
So you knew of her, you just didn't have a business relationship or a personal relationship with her, or at least a close one.
I knew of her from she was in the DA's office and I had criminal cases, but I did not personally know her, no.
And not having known her, not really hanging out with her, you've got a contract from her office.
I'm gonna just object as to cumulative asked and answered throughout the
All
multiple
right,
days.
Mr. Sheriff, I think we covered this ground on the 16th about the contracts. Do you have are you going somewhere else with this?
I am, Judge. If you give me a little latitude, I'll tell
All
you.
right. Okay, you may proceed.
You got a contract from the office, not knowing or having a good relationship or a good working business relationship with Ms. Willis.
That's correct.
That's because Nathan Wade steered that contract to you.
I don't know how it came about, but it was presented to me at the office about the contract, correct?
Who presented it to you? Mr. Wade?
Yes,
And he owed you money, you said at one point.
say that again?
I think you said he owed you money at one point.
I don't recall saying that he owes me money.
Did he owe you money at one point?
Not that I recall saying that Mr. Wade owes me or owed me money. I don't recall ever saying that.
I didn't ask whether you ever said that. I said, did he owe you or did he owe you money in the past?
No, he didn't owe me money.
And so he steered this contract to you, to your office, and you weren't really talking to him? You hadn't talked to him for 2 years?
The contract was in 2021. I didn't leave until 2022.
So you didn't talk with him that whole time?
I left in 2022. I haven't really spoke to him since 2022 is what I stated. When I left June of 2022, around June, August dates of 2022.
Other than one last question, other than your attorney, who did you speak with today about giving testimony in this case today?
I spoke to my attorneys, Charles Graham and BC Chopra.
I have nothing further, Your Honor.
All right. And again, I'll just double check to make sure. Did Mr. Cromwell ever join us by Zoom? Do we?
He's still having technical issues.
Okay.
He did email me saying he has no questions. It appears that all relevant questions were asked.
All right, thank you. So just for the record, Mr. Cromwell has been apparently watching the proceeding. He had waived his client's presence and didn't have any other questions as well. So turning it over to Mr. Abadi.
And I have no questions.
All right. Mr. Bradley, you can step down. Thank you, sir.
Judge, you want these exhibits?
Yeah, I'll take this one. Good night.
May I
All
be
right.
excused?
That's right.
I have a follow-up based on some questions from counsel, and it's just about the text.
And what, just by way of proffer, what about the text?
Just to admit, so when other people asked about the text, some of them weren't in the record today, so I organized them. They're the ones that have been talked about today, so I just organized them. I just wanted for point of reference to have them. That's
Okay,
it.
okay. And do we need Mr. Bradley for that?
I don't believe so, but
Have you marked them?
yes,
Have you showed them to the state?
I gave a copy to the state, but so these
Mr.
are.
Bradley, just hang on just for 1 second, just
I
to
know.
make sure.
I'll give you all of them. so.
Admitting all of them? Or not?
You can, you must. If you want. I don't want to object.
And I think it's fine. Yeah.
And while he's looking at that, Mr. Bradley handed me Defense Exhibit 23, 24, 25.
Judge, I didn't realize that they were
This-
in my folder.
Oh, is that from the hearing?
That-
From on Friday?
Here, so-
All right, well, thanks for returning those.
Fine, if you want that
Uh,
out. The reason I put those in is because you.
Let me make sure.
As long as you admit it.
So cool. Because of your objections. Front part and the back part of this. You have an objection to any of them, you can tell me, or you can admit.
Okay, so I've got 23, 24, 25. Anything else in your binder? All right, good. Okay, and have we come to any conclusions on, what, I'm sorry, how did you mark it?
I think we're up to 39. Surprisingly, the state objects.
All right. Defense Exhibit 39 is tendered and admitted without objection.
Well, no.
Oh, I'm sorry. Oh, okay.
Text messages that weren't referenced today with, or confronted, with,
Okay.
as it relates to Mr. Bradley.
So these are additional text messages, Ms. Merchant?
Yeah, so what I did was they objected that they weren't complete because like the first part of the text wasn't there. It was just like, oh, there was something before that was said. So what I did was I spent this whole time trying to line them up so that I had the beginning of the text, the middle, based on their objection. They have all the text. They can admit all of them if they want them complete. And
All right. How about, I'll just do this. Just, I understand the desire just to have the complete text chain, just for purposes of completing the record. I think that there's no point in having him sit here and authenticate every single one of them. So I'm willing to admit it as a court's exhibit. And only the exhibits, though, that had been previously tendered or referenced in testimony would be ones that actually are relied on for making any findings. But just so it's on the record, we have the complete text chain, should that ever be an issue for some reason. Any thoughts about that, Mr. Abadi?
My only thoughts are this is not the complete text chain. I was
Yeah.
to briefly look at Miss Merchant's phone when she allowed us to have it for a couple
Okay.
of seconds, minutes, and there are text messages I know that I saw that are not in what is purported to be State's Exhibit 39.
Okay.
it's not
All right.
complete
Ms.
text.
Merchant, what about that?
I let them take screenshots of the ones that they thought weren't there, and he sent them to himself on my phone. I have also offered to hook my phone up to whatever it is. My phone's an iPhone. His is an Android. I can't download like you could in a normal text. I told them if they had a system to get all of my texts, they can have every single one of them.
We can definitely do that.
Your Honor,
Yeah, Mr. Rice.
text that she's submitting now and tendering into evidence are specific parts of the conversation. The entire text chain isn't a continuous conversation subject to Rule 601. Those particular parts, given the witness's testimony, should be admitted as substantive evidence to prior inconsistent statements with this testimony today. It would be up to the government and the state if they then want to introduce the rest of it. Have at it.
Yeah. Sure. I think that's a fair point that if he had been confronted with a particular text, that could have been the opportunity to admit it as a prior inconsistent statement for impeachment. And some of them were, but apparently some of them were not.
I'm taking those out. So I'm taking out the ones that they said he wasn't confronted with, and I'm just going to admit the ones that he was confronted with. That's fine. It just makes it more confusing, but it's fine.
All right. So we have a newly marked, newly compiled 39. Let's see what the state thinks of that one. All right. Regardless, if that's now what is being discussed, again, I don't see a need for Mr. Riley to be here any longer. So I'm going to excuse him at this point. Thank you, Mr. Bradley.
Judge, may we be?
Of course. Take care.
released from the subpoena?
Yes, that's right.
It was preferred.
It's funny, the last time I did it was with Miss Cross.
But you didn't confront him with them.
When Miss Cross had met witness.
Yeah.
I did that one. And this we can talk about, yeah. Okay, so
So where are we with Defense Exhibit 39?
it might be helpful if you looked at them so you know what we're talking about, but I confronted him with all of
This
these.
is your, this is 26. You've already got it.
Right, I know. So
So you're.
Exhibit
you put it on
26.
record.
I put in so that it made sense, so you can read it. You know, when you're reading a text and it's a conversation,
Sure.
they're upset that they're not in order now, I guess. I don't really understand, but if you want to look at them, you can.
Well, let's start from the beginning. What is the purpose of Defense Exhibit 39?
These are the ones that I showed him and that I showed him today. So there were a lot of follow-up questions on it. And so I realized, okay, well, they should just be in the record because other people are referring to my texts and they might as well just be in the record. And he authenticated all of them.
All right.
So
And Mr. Rice?
Not just in the record, Judge. They should be admitted as substantive evidence because they come in as prior of state.
Okay. All right. So to that end, Mr. Abadi, is there a particular text message in there you think was not authenticated? I understand you're saying, well, maybe one of them's already been admitted. So, but otherwise, just having a omnibus, here are all the relevant text messages exhibit. Is there an authentication objection? Is there any other kind of objection like that?
Yes, because he didn't authenticate that all of the text messages were from him in between Ms. Merchant or the context of them. So I think that's the problem. When you don't, for example, if the state was to provide, I guess, just a specific text chain from a cell phone extraction, there would be an objection because the state would be making the determination as to what is relevant. Really, all the information should be turned over, and it's for the parties to object and Your Honor to determine which parts of the conversation are relevant or not. I don't have all of the conversation. The conversation starts in September, and then so there's a few text messages from September, and then we jump to January. Ms. Merchant has determined that jump in between is not relevant. That's not appropriate. It's for Your Honor to determine what's relevant and not. And I can't make an objection as to what I don't know. I can tell you what I've read. It seems as if there are definitely parts that are missing that would make certain parts of the text message she's attempting to admit that she didn't confront the witness with would be my objection. But only the relevance can only be determined if we have the full chain. So she's determined which ones are relevant. That's your job.
Sure. So didn't she just try to do the full chain as an exhibit just a moment ago?
No, we don't have the full chain. The full chain is text messages that begin in September and continue down. That's not contained in that entire package. They're on her phone.
Okay.
She'd like us to do it in just that chain.
All right,
Have to do
Ms. Merchant,
the technology.
and then Mr. Gillen.
Not a problem. And I offered that when we were here before, and I was told they didn't have that technology. But let me just go through them one by one. It might be easier. I was trying to just do it quickly all
You
together.
can just hand them to me.
So the first.
Just hand them to me. I can read them. And
I marked them all separately.
while I'm reading them, Mr. Gillen, what did you have to add?
Brief point, Your Honor. Apparently, Ms. Merchant has allowed the state to take screenshots of what they now contend would be the larger perspective on, and I disagree with them about the rule of completeness, but it's their job when something is admitted that if they have an objection because the context is not appropriate, they then move. And the state should move the rule of completeness, the admissibility of the other emails chain that they had. So the real issue here is their failure to comply with the rule of completeness once they have the material from the last hearing that they took screenshots of.
Well, isn't that what he's doing now? Because now they're being tendered?
No, I don't think that he is. I mean, it seemed to me that what was happening here is this Ms. Merchant has tried several different ways to get it in. She wanted everything in and they objected to that. And she wanted the segments in that had been, the witness had been asked about, and that's what she's trying to do. My point is that if they're at the time of frankly of moving under the rule of completeness is at the time of the tendering. If they want to tender something to show that it should be included to be complete, that's on them,
Sure.
not on Ms. Merchant.
All right, Mr. Abadi, last point here.
So I had a very limited time with Miss Merchant's cell phone. I only had time to literally find one part of the text message to then send to myself before Miss Merchant demanded her phone back. So I did not have the opportunity to screenshot every act or every missing part of the conversation to then do as Mr. Gillum is saying that should be done, but it can't be done if I don't have the information. So you don't have the complete packet, and there are many of the text message screenshots that you have printed out that were not used to confront Mr. Bradley or refresh his recollection. So they're inadmissible evidence. If anyone missed the opportunity, it was the defense counsel
Sure.
to confront him.
All right. I don't think we need to go back and forth any further. Ms. Merchant, you said to print out a complete chain of every text exchange with Mr. Bradley since you began corresponding with him. I'll give you the chance to do that, and you can follow up by email with that exhibit. It would be the complete chain without any deletions or removals, and we'll have that marked as Defense Exhibit 39.
Judge, I
And-
have got to respond though, that in court
There you go.
Friday at 1:57, when Mr. Abadi texted himself the screenshots, I literally wrote him, do you want any other screenshot? I have nothing to hide. You can download my phone if you want. So I,
All right, we're done. Okay, so I'll wait back to hear from y'all on Exhibit 39. And is there anything else to take up before we discuss Friday? Just kind of throwing it open to the floor. Seeing none, I believe I'd asked and put it out there among defense counsel to be considering how they would like to organize their arguments on Friday. Has there been any decisions reached on that?
to determine that,
Okay.
and I can email the court when we're done with that, but we are going to make it as efficient as possible and break it up.
Break it up in terms of like subject matter or something like that?
There's time limits.
Yeah,
That's large.
yeah,
Let us know.
that's the idea.
You can tell us what that'll be, and then
Well, I'll start with, what is it that you're asking for? And we'll start there. It's kind of curious.
Well, I don't think
Yeah.
we can answer that right now. Number one, the court said, look, if you divide it up, then we can go with that. Or if you can't divide it up, then I'll give each defense counsel a specific period of time. Tomorrow, we'll find out when we meet whether or not we can divide it up in a way that serves the interest of our respective clients. Hopefully we can. We can communicate with the court.
Okay, I'll just wait to hear from you. To the point of, I think the state recently filed their own motion to, I think it formally had to reopen the evidence as to another witness. I only got to read it very briefly, or I don't know if that was just saying in the alternative, we'd like to reopen the evidence. I don't know, maybe someone can clarify that, but my thought there and what I think we ought to do Friday and what I would like to do on the issue of the cell phone analysis and this other affidavit filed by the state today is that both parties, any party rather, can make whatever arguments they want based on a proffer, any counter arguments they want to make based on a proffer. They would not be admitted into evidence at this point. And at this point, I need to start hearing the arguments in the law and what we've heard so far. And if I think I'm able to reach a ruling based on that, I will. However, if I think that
It's very hard to read, so let me ask it this way then. Do you recall paying around $1,269.70 for a Royal Caribbean cruise for you and Miss Willis? You don't remember that?
That amount seems kind of small. I don't. I think
Okay,
it's-
so you believe it was higher?
Yeah.
Okay. While you were in Aruba, then you bought a cruise, a Norwegian cruise, right? And that was the New Year's Eve cruise?
While I was in Aruba, no, ma'am.
The credit card documents that were admitted earlier show the purchase date when you were in Aruba, but you don't remember doing that in Aruba?
I didn't purchase a cruise while I was in Aruba. That may be when the cruise company decided to run the invoice, but I didn't purchase a cruise in Aruba, no, ma'am.
Around the time you went to Aruba, you purchased a cruise for Norwegian for you and Miss Willis to take for New Year's, correct?
Before I went to Aruba, yes, ma'am.
And that was roughly $3,387. The cruise to Aruba. I mean, the Norwegian cruise.
So that cruise was with my sisters.
Okay.
And the number that you are seeing would reflect my buying dinner for my sisters and their husbands.
I'm just talking about the cruise, the amount that was paid for the cruise ahead of time when you booked the cruise. I'm just talking about that.
Okay.
That was a little over $3,000.
Yes, ma'am.
Okay. So, and I understand you're saying you paid for other things, but I'm just talking about the cruise amount. Okay. And you paid for a Jeep and you paid dinner while you were there in Bahamas.
Yes, ma'am.
That's the one that Miss Willis paid for a flight for, correct?
That's one of the flights she paid for. Yes, ma'am.
Actually, a documented paid for, not cash. I'm talking about a non-cash transaction. That's what she paid for.
You mean the one that I provided the receipt for?
Yes.
Yes, ma'am. That's that.
Okay. And so she booked that on her credit card and wasn't worried about, I know you said earlier that you were booking everything because she was worried about people knowing where she was traveling. She didn't have any fears booking that one though, correct?
I'm going to object to the phrasing of that question, speculate as to what was the motivation of the district attorney. She wants to ask if that was the transaction, and he responded that was the transaction.
Ms. Merchant, I think you can rephrase the question, but I'll just state on the current phrasing.
So she purchased that under her own name, correct?
She did.
Okay. Let's see. So I know we talked a little bit about the seminar where you all met. Isn't it true that you would go to Miss Willis's house in South Fulton County occasionally?
I've never gone to her house in South Fulton County.
You've never gone to her house in South
I've
Fulton
never
County?
seen her house. The first time I even heard the address of that house was when one of the individuals in the election fraud case somehow doxed it and it got out. That was the first time I'd even seen that address.
But you would go to the East Point condo, correct?
What East Point condo?
East Point, Hapeville, something like that.
I've never been to East Point with Miss Willis.
You've never gone to a condo in either the East Point or Hapeville area with Miss Willis.
Wait, that's different. I have gone to a condo in Hapeville.
Okay. So Hapeville.
Yes, ma'am.
So you have gone to a condo with Miss Willis in Hapeville.
I have.
Have you spent the night there?
Never.
Never spent the night there.
Never.
Is that the condo that was rented by Robin Yearby?
I believe it was.
And other members of the DA staff were there as well, correct? Sometimes.
I've never been around other members of the DA staff at a condo in Hapeville.
There's never been any security for Miss Willis?
Not around me.
Did you ever ride with Miss Willis with her security detail to and from the house?
No.
You served on Miss Willis's transition team, correct?
Yes.
And you were part of all of her interviews where